Well, a very good afternoon to you all, to the second in the recent series of our infrastructure seminars. The three of us are going to be speaking this afternoon on recent legal challenges. We have Mark Westmoreland Smith, a very experienced junior at Francis Taylor Building, dealing with major infrastructure projects and compulsory purchase. He has successfully promoted numerous development consent orders through the process, including without a leader. At the moment, Mark, I think you're promoting the KEED B3 carbon capture scheme and advising government on a range of DCO projects. And Mark, you're also a member of the A panel. Esther is going to speak second. And Esther, you're a junior tenant at Francis Taylor Building, busy practice. You also advise the government, don't you, through the junior scheme. And Esther was in fact involved in Pierce in the early stages of that litigation, and then is going to be speaking on that very subject later on this afternoon. So Mark, I'm going to hand over to you now. I think we're going to switch off our cameras, Esther, and we'll see you a little bit later.
Thank you very much, Melissa. I will try and share my screen. Which I hope right. So let's I hope that's successfully showing my cover.
Yeah, right, that's perfect.
Great, excellent, thank you very much. Well, what I'm going to do today is look at two recent cases of my own, which have given rise to some interesting and important points about the Planning Act regime itself. The two cases that I'm going to look at are EFW Group and Tidal Lagoon Swansea Bay. Both happen to be great Chambers outings. I acted with Michael Humphreys QC in EFW Group, and Ned Westerway was for the Secretary of State. And then in Tidal Lagoon, Michael and I split up, and he was for the developer and I was for the Secretary of State. And Amir Jones acted for the Welsh Government, and then Douglas Edwards QC for Swansea Council. If I start then with EFW Group, and there's a picture there of part of the development, because part of it was an extension to an existing plant. This was an unusual case because it was a case where the developer itself challenged the grant of its own development consent order because it didn't get everything it wanted to. It had applied for a single development consent order, but which would authorize two distinct projects. The first was an extension to the existing energy from waste facility that you can see there, known as K3. And that on its own met the definition of a nationally significant infrastructure project. The project for K3 simply involved increasing its permitted capacities and didn't require any physical works in order to achieve them. And the second was a separate and new energy from waste facility that was to be built immediately to the north of K3. It was called WKN. And this facility fell below the NSIPs threshold when one looked at it on its own. So my client applied for a Section 35 direction for WKN to be treated as development for which development consent is required. And the Secretary of State granted that direction. He was satisfied that cumulatively the developments located on essentially the same site comprised a significant facility of national sustainable energy supply. But in the end, the Secretary of State granted consent for the extension of K3, but not for WKN. Now, what this meant, unusually, was that a successful challenge would result in my client losing consent for the extension of K3. So this meant that my client had to make a judgment about the risks on redetermination and the potential to lose the K3 extension consent, in particular in the light of the evolving situation around the energy national policy statements. When it came to the decision making, the examining authority examined the application on the basis that Section 104 of the Planning Act 2008 applied to K3 only, and it applied Section 105 to WKN. So the examining authority made its recommendation on the basis of applying two different statutory approaches to determining a single application for a development consent order. The Secretary of State disagreed with that approach in his decision letter. He said a single application must be determined under Section 104 or 105, saying they were mutually exclusive. However, in a twist, in defending the decision, the Secretary of State disavowed that approach, saying that the EXA had been right after all, and that he had made an error, but argued that it was not a material error of law, as it would have made no difference. I said it was unusual. So we had the claimant attacking its own consent and the Secretary of State attacking his own decision. Our case was that the Secretary of State had been right to apply Section 104, and that the difference between the Secretary of State's approach at the time he made the decision and that taken by the examining authority had given him a real problem, because he had a very detailed report and recommendation from the examining authority that, in respect of WKN, was based on what we said is a fundamentally different decision-making framework, i.e. 105, than he thought should be applied 104. And so we said that he had a really difficult task to unpick the examining authority's report, and in particular the conclusions of the examining authority that were as a result of the examining authority having examined the application on the basis that there was no relevant NPS in relation to WKN. But instead, what the Secretary of State did in the decision letter is simply state that he had determined it under 104 and that didn't make a material impact to the overall outcome. And sort of frequently in the decision letter, one can see on issue after issue the Secretary of State saying he sees no reason to agree with the examining authority's conclusions on that particular matter. And we said that just didn't give effect to the fundamental conclusion that the whole application should be considered in the legal and policy context of 104 rather than 105. So, for example, there was nothing in the decision letter that indicates that the Secretary of State properly applied to WKN the presumption that the application be determined in accordance with the NPS, judged as a whole, or if he did, what his conclusions were, or indeed the presumption in favour of energy developments that is housed in the relevant NPS. So we said there was a failure to properly give effect to Section 104. But the 2 points of wider interest in the case really arose due to the Secretary of State's disavowal of what he'd done in the decision letter. And the key arguments became the relationship between Sections 104 and 105 and the effect of a direction under Section 35. So with that, we just need to look very briefly at the relevant legal provisions. The first of which is Section 35. And this allows the Secretary of State to give a direction for development to be treated as development for which development consent is required, where it complies with the conditions that are set out in subsection 2. In particular, it needs to be in a specified field, and the Secretary of State needs to think that the project is nationally significant, either on its own or in combination with other projects in the same field. Secondly, section 104, as you'll be aware, this is the key decision-making provision where there is a relevant NPS. I've set it out, or at least the material parts of it out on the slide. Note the language. It applies to an application. And of course, it's subsection 3 that places NPSs at the heart of decision-making in the 2008 Act regime. Then we have 105, the other side of the coin, entitled Decisions in Cases Where No National Policy Statement Has Effect. And subsection 1 states in terms, this section applies in relation to an application for an order granting development consent if section 104 does not apply in relation to the application. It was on this basis that we argued that the sections are mutually exclusive. So what were the arguments? Well, in brief, our submissions were that the Secretary of State had been correct in making his decision by applying 104 to the application as a whole. We said they're mutually exclusive, and that could be seen from the language. Both 104 and 105 refer to those sections applying in relation to an application for an order granting development consent. Thus, where there's an application for which the NPS has effect, it is to be decided within the 104 framework. And we said that the Secretary of State was in effect seeking to read words into 104 by treating it as if it included words to apply the provision to part only of an application, and similarly with regards to 105. Finally, we said in relation to a direction under 35, section 35, that was a direction to treat the development proposed as development for which development consent is required. And treat as, we said, simply means what it says. By contrast, the Secretary of State said that the starting point was the terms of the NPS itself. So you look to the NPS to work out whether it's relevant. And NPS EN1 says that it applies to development over the section 15 thresholds of 50 megawatts, and WKN didn't meet that. And so to apply section 104, it was said would effectively expand the intended application of the NPS. And the Secretary of State said that 105 can be read more broadly than the language used, including the words, for example, where or to the extent that section 104 does not apply to the proposal. And that's really the converse of what we were saying. And then finally, the Secretary of State said that a direction under section 35 was like purely procedural. It only decided the consenting route by directing a project into the 2008 Act regime. It did not require a project to be treated as if it were bigger than it was. So sadly on this one, Michael and I came out on the wrong side. The judge essentially agreed with the Secretary of State. He saw some force in our argument about the wording of 104 and 105 and its relation to applications, but came to the view that overall the Secretary of State's arguments were to be preferred. And I think the two key passages in the judgment are probably paragraphs 58 and 59, and I've given you those in the slides. In summary, the judge emphasized the centrality of the NPS to the regime and concluded that seeking to apply them to a scheme that did not fall within the NPS parameters would be to impermissibly alter the NPSs. And I'll come to my views on whether or not that's right in a moment. On section 104, 105, the key passages in paragraph 104 paragraph 59, where, halfway down, the judge says section 105.1 should be interpreted as applying to those discrete elements of an application which comprise proposals for development for which no NPS has effect. I accept the submission of the defendant that section 105 of the 2008 Act should be interpreted as applying to freestanding parts of an application to the extent that section 104 does not apply in relation to the application. Such an approach, he says, reflects the purpose and intent of the legislation without unduly disturbing the effect of statutory language. Thus, the EXA was correct to take the approach which it did. As to the question of whether or not the section 35 direction had the effect of bringing WKN within the scope of the decision-making framework pursuant to section 104, the judge said he couldn't accept that a section 35 direction has the effect of turning a project which does not fall within the definition of NSIPs into an NSIP. He said the words be treated as simply have the effect of making the proposed development subject to the provisions of the 2008 Act. And for those reasons, he found that the defendant did in deciding that 104 applied to both, but said the error wasn't material, essentially because he said it was advantageous to have the benefit of the presumption under 104 to the applicant, and the outcome could only have been a refusal without that presumption. But of course, what the substantive ground sought to establish was that the presumption wasn't properly applied, but that wasn't in the end the focus of the case, or indeed accepted by the judge. And unfortunately, the Court of Appeal has just last week refused permission, in part on that discretion point, but also supporting the judge's wider conclusions. So that is the law as it is, as it stands, and but I do harbour my doubts as whether it is correct, because the deeming provision, section 35, by definition treats a smaller scheme as if it meets the NSIP threshold. Why? Because there has to be a finding that it's nationally significant. And if it does that, and there is a relevant NPS, so for an energy scheme, the energy NPS EN1, why would the key policies, the central plank of the NSIP regime, not be applied? I think it might be said that this decision, in effect, rather than augments the NPSs, actually undermines their centrality, not the other way around. And the irony is, given that the government's approach through this is they plainly agree, because in the draft NPSs that were being drawn up while this litigation was ongoing, on the one hand in the court, they were saying, look at the terms of the NPS, and on the other, were redrafting the terms of the NPS to make it explicit that they will apply, or at least the energy ones that are being redrafted, apply to projects directed into the NSIP regime under section 35, and in effect neutralising the judgment in that regard. So now, if seeking a section 35 direction for a project either in the field of energy prior to the draft policy coming into effect, or other projects where the NPS doesn't have similar wording to the draft EN1 wording, it would be sensible to seek a procedural direction under section 35 ZA from the Secretary of State that any relevant NSIP should be applied, or any particular NSIP should be applied. So that's EFW. Swansea Tidal Lagoon is another interesting one, where the developer applied for development consent to construct a tidal lagoon electricity generating station across Swansea Bay, and that's one of the developer's images of it. The order was made on the 9th of June 2015. It came into effect on the 30th of June 2015. Subsequent to that, the developer carried out certain ground investigation and survey works, including boreholes and trial pits. And the developer also entered into funding negotiations with the government, but the Secretary of State announced fairly shortly afterwards that he didn't regard the project as value for money, and work on the project was paused. But the developer saw an opportunity with net zero and sought to reignite the project. And in May 2020, wrote to the Secretary of State and pointed out that the order would expire on the 30th of June 2020, requested that the government should enact a one provision bill that would result in the extension of the powers under the order by a further year. That request was rejected. The Secretary of State said, no, you've got to be ready to implement your consents. And if you need more time, apply for it properly under Schedule 6 and do that in a timely fashion. And we still don't think it's value for money. So the developer then changed tack, and he wrote to the council, Swansea Council, the day before the 30th of June 2020, when it was said that the order, he had said to the Secretary of State, the order would cease to have effect, and said that the works undertaken to date, the trial pits and excavations, etc., had amounted to material operations for the purposes of Section 55 of the Planning Act. And so the development had been begun, and so it wouldn't cease to have effect. And this was a new line of argument, sort of contrary to this position taken in May. And it was this line of argument that was the subject of the claim. So the claim was Part 8, no material disputes of fact. Indeed, there was an agreed statements of fact, and the issues raised were of pure law. The developer sought two declarations. It's really the first of those that's important, and on which the case turned. It was essentially agreed between the parties that the second declaration followed the first. So that the first declaration was that the development has begun, that it has begun the development for which the order granted development consent within the meaning of Section 155 during the period required by virtue of Section 154. So the key provisions in the order are there. Article 2, which defined commence. Commence means to begin to carry out any material operation. That was defined by reference to Section 56 of the Planning Act, and then with carve out for relatively minor preliminary works. And requirement 2 required the authorised development to commence no later than the expiration of 5 years, beginning with the date of that order coming into effect. Article 27 also placed effectively a 5-year time limit on the CPO powers. Key relevant parts of the Act, Section 120, which governs what can be included in a DCO. Subsection 5 says an order granting development consent may apply, modify, or exclude a statutory provision which relates to any matter for which provision may be made in the order. 154 provides a default time limit on DCOs. It's 5 years or the period to be prescribed in the order. And then subsection 2 states if the development is not begun before the end of the period applicable under subsection 1, the order granting development consent ceases to have effect at the end of that period. Section 155 defines material operation and what it means for development to begin. Material operation is very widely defined. The only prescribed operation is the measuring or marking out of a proposed road, which wasn't relevant in this case. So the developer accepted that the development had not been commenced under the order itself, but argued it had been begun for the purposes of the Planning Act and 154-155, such that the order hadn't ceased to have effect. And that meant that the developer could apply to amend the order and allow for a longer period to commence development. It said that the order didn't exercise the power in section 120, subsection 5, to modify or exclude the application of 154, because there was no indication that it was doing so in the order itself. And it also said that the words begin and commence were used for distinct purposes and are separately defined so as to have their own technical meaning. Begin in section 154 relates to the duration of an order and when it ceases to have effect, and commence in articles 2 and requirement 2 were dealing with pre-commencement conditions or requirements. And that gave a clear and distinct rationale for the use of the two words in their distinct roles. By contrast, my argument was, well, look, the starting point is to look at the order itself. That's what we're interpreting and the language used. The ordinary meaning of commence and begin is the same. Commence in any event in this order was defined to mean to begin, and so equates the one with the other. And so far as the purposes of the relevant statutory provisions are concerned, that is to limit the duration of an order so that promoters must use or lose their consent. And that's particularly important in the context of DCOs, where there are often compulsory purchase powers incorporated into the orders. And time limits are there to protect individual landowners from indefinite powers of compulsory purchase affecting their land. And the effect of the rival contentions, or the company's contention, was that the order runs in perpetuity, despite the fact that it has not been commenced, and that can't be the intention. And furthermore, there's no requirement within the legislation to signpost any modification under section 125. And the definition of commence in the order did in fact modify section 155 to allow investigation works to take place prior to commencement. What conclusions did the judge come to? I've laid this out on this slide. He accepted that the task before him was to construe the order itself. He agreed begin and commence were synonyms, and that Article 2 did equate those words to one another, which indicated no distinct meaning, but he said that the carve out of certain words could point to a distinction in meaning. The failure to indicate an intention to modify or exclude sections 154, 155 was a factor in support of the developer's case, but given that there was no statutory requirement to make any such indication, not a strong one, but noted that as a matter of good drafting, such an intention ought to be indicated. And so that's a learning point to take away for those in the industry. And he accepted the defendant's submissions that the purpose of the requirement was to limit the life of the order. And in terms of consequences, he found defendant's submissions compelling. In particular, he accepted that if the order remains extant, then so does the prospect of compulsory purchase, and concluded that the outcome of the developer's contentions that the order is permanently alive and can be modified so it can be commenced to be unsatisfactory. By contrast, the defendant's submissions did not lead to an unsatisfactory result and involved a clarification of and no injustice to the language used. So for those reasons, he did find for the defendants. It was a really interesting case because Michael's case was very much black letter law based on statutory language. and the fact that the provisions define each of the terms. My case was more on a purposive construction and the consequences of the rival contentions. And the advantage of my approach in this case was that it avoids the practical problems created by the black letter approach. And in the end, that's why the courts sided with me. There's an application to the Court of Appeal for permission. So it's one where we still have to watch this space. Just finally, in terms of the points to take away from that case, it seems to me that the issues can actually be dealt with by prospective applicants very easily by ensuring that the drafting within the order reflects the language used in the underlying act. I have to say, most orders don't, but that might be something to be taken away from this case, and a change to be made in drafting habits. So use begin instead of commence. Moreover, if you're utilising the power under section 120, subsection 5, make it clear you're doing so. That's an express request, so to speak, of the judge, and it seems to have some value to me. And for those with an extant development consent, just be very aware of timeframes and seek to spot any potential difficulties early, act upon them whilst you have time to do so, and try to avoid having to make an application to extend only a few months before expiry. I mean, that seems to me to be a matter of common sense, but it's a real problem in practice. I think this is the third case I've advised on recently in relation to the expiry of development consents. In the other two, I was advising the developer and advising on steps to keep consents alive. And I think this is just a reflection of the complexity of funding, procuring, and sometimes the amount of pre-commencement works under requirements. And these factors can conspire to make 5 years a surprisingly short time frame. So I think the short point to finish on is that developers must be alive to the ticking clock. And with that, Minister, I'll hand back to you to introduce Esther.
Thanks very much indeed, Mark. Really useful. Now, we've got one question or maybe a comment. I think my preference, unless anybody's got a strong view to the contrary, would be to tackle all questions or comments at the very end. So I think I will just then pass over to you, Esther, straight away.
Thank you. I'm just going to start my presentation. Hopefully you can all see my slides now.
Yep, that's perfect.
Great. So I'm also going to discuss two challenges to development consent orders, the Client Earth case and the Pierce case. These were both also Great Chambers outings with almost all counsel in both cases, members of FTB. Mark was also involved in the Drax case on behalf of the developer. So starting with Client Earth or the Drax case, this was a challenge to a DCO for a gas-fired power station in North Yorkshire. The examining authority had recommended withholding consent on the basis that there was no identified need for the development. And in fact, it held that no weight at all should be given to need on the basis of changes to energy generation since the EN1 NPS had been published, and projections of future demand for gas-fired electricity generation, and also the pipeline of consented gas infrastructure. It also gave weight to the significant adverse effect identified in respect of greenhouse emissions from the development, and on that basis found that the development did not accord with the energy NPSs. In relation to the overall planning balance, it found that the adverse impacts outweighed the benefits. The Secretary of State disagreed and granted development consent, relying in particular on the presumption in favour of fossil fuel generation and assuming a general need for such energy generation. It didn't draw, the Secretary of State didn't draw any distinction between the general need identified in the NPSs and the need for a particular proposed development, and therefore found that one should give substantial weight to any project contributing to the need. It also held, the Secretary of State also held that greenhouse gas emissions were not a reason to withhold consent, and that the benefits outweighed the adverse impacts. In the High Court, the claimant advanced a wide range of grounds, as I've listed on the slide there. All of these grounds were dismissed. A few points in the judgment are worth noting. So first, there was a strong emphasis in the judgment of Mr. Justice Holgate on the fact that DCO decisions operate in a market-based system. So the market should determine how much infrastructure, what type, and where that infrastructure should be in the transition to a low carbon economy. DCO decisions taken in accordance with NPSs are only one of a number of vehicles in the delivery of energy and climate change policy. Mr. Justice Holgate held that EN1 did not require any quantitative assessment of the need for any individual application. And there's an implication in his judgment that the quantitative assessment was in fact irrelevant, and that to rely on any such quantitative assessment of need would be effectively rewriting the NPS. On greenhouse gas emissions, he held that it was lawful to consider whether such emissions should be given greater weight under the Section 1047 Balancing Act than they were given in the NPSs, as long as greenhouse gas emissions were not treated as a freestanding reason for refusal. But he held that the Secretary of State had dealt with such emissions lawfully. The claimant advanced 3 grounds of appeal in the Court of Appeal. Under the first ground of appeal, the essential argument was that policy on need in EN1 requires an assessment of the particular contribution a project will make to meeting the need for the relevant type of infrastructure. So it wasn't sufficient to simply rely on the general reference to need in the energy NPSs. A quantitative assessment was indeed required, and EN1 requires a decision maker to consider case by case the anticipated actual contribution of the individual project to satisfying the need for a particular type of infrastructure. And the claimant relied in particular, the appellant in the Court of Appeal relied in particular on the final sentence of paragraph 3.2.3 of EN1, which I've put there on the slide as indicating the requirement for a quantitative assessment of need. By ground 2, the claimant, the appellant, argued that the Secretary of State misinterpreted EN1 as requiring the decision maker to treat the greenhouse gas emissions of the development as either irrelevant or having no weight, and also challenged Mr. Justice Holgate's interpretation of EN1 as preventing greenhouse gas emissions from being a reason for withholding consent for an energy NSIP. You'll recall he said that they could not be treated as a freestanding reason for refusal. Under ground 3, the claimant argued that the Secretary of State had failed to discharge her obligation under Section 1047 to weigh the adverse impact of the proposed development against its benefits. The claimant argued that she had simply repeated the assessment she'd already undertaken under Section 1043 when considering whether the development was in accordance with national policy statements. And so in effect, she had fettered her discretion. As the High Court, the Court of Appeal also dismissed all grounds. It made some important wider remarks on interpretation of policy, in particular national policy statements, reminding us that policy must be interpreted objectively, in context, and having regard to its evident purpose, and also that it should be read in a way which renders it consistent with other provisions in the same policy. So applying this to the weight to be given to need, or to the assessment of need, it's important to read paragraph 3.2.3 of EN1 as a whole and in the context of the whole of EN1. And the penultimate sentence before the one quoted on a few slides ago referred to the need to give substantial weight to considerations of need. And the court also had regard to the fact that in other parts of EN1, a presumption in favour of fossil fuel generation is identified. The final sentence of paragraph 3.2.3, considered in that context, allows the decision maker to depart from the fundamental policy that substantial weight must be given, but doesn't require a quantitative assessment of need. Ultimately, it's a matter of planning judgment, as the contribution to need that any development might have involves predictions about the future, and neither law nor policy prescribe a single way of performing that task. There aren't any specified considerations which must be taken into account or must be excluded. And in particular, and importantly, no requirement that the assessment should be done on a quantitative rather than a qualitative basis. So the bottom line on need is that there is a wide discretion for the Secretary of State as to how to carry out the assessment of need and what weight to give to it. Even though the NPS says substantial weight must be given to need, the decision maker can lawfully depart from that assessment. On greenhouse gas emissions, the court held that such emissions are not an automatic obstacle consent of themselves. And in particular, it relied on the fact that if they were considered such an obstacle, that would conflict with the presumption in favour of granting consent and the need to give substantial weight to considerations of need. So this is where the point about not reading the policy in conflict with itself was relevant. However, greenhouse gas emissions are a potential material consideration, and the weight to be given to them is a matter for the decision maker. And the court explicitly differed from Mr. Justice Holgate's conclusion in the High Court that greenhouse gas emissions are not capable of being treated as a freestanding reason for refusal. Crucially, with regard to the outcome, the fact that the Secretary of State accepted significant adverse effects from greenhouse gas emissions would arise, but considered that this did not conflict with policy EN1, and also recognised that it was open to her to depart from the NPS policies, meant that she had taken a lawful decision. On section 1047, the court held that this involves a straightforward balance, setting adverse impact against benefits. It's not expressed as excluding considerations arising from NPSs. So it is lawful to take into account and give weight to the need for any particular type of infrastructure recognised in an NPS when carrying out the section 1047. However, it also was a useful reminder that this balancing act does not provide a means for challenging the merits of the policy set out in a national policy statement. In the present case, there was no question that the Secretary of State had fettered her discretion. She did not adhere slavishly to the policies of EN1 and EN2, and she also again acknowledged that she was free to depart from the NPS policies and give greater weight to the greenhouse gas emissions, although she declined to do so. So just some points of interest or wider learning from the case. As I've already mentioned, it's a reminder of the importance of context and reading a policy document as a whole when interpreting it. The claimant's approach, which focused on particular sentences, was not the correct one, and didn't give rise to the correct approach to assessing applications. And again, it's also necessary to avoid interpretations which result in conflicts between certain elements within a policy. For now, this case settles the approach to need and greenhouse gas emissions in EN1 and EN2, although, of course, these documents are currently under review and the government response to that consultation is awaited. It's worth noting that the draft text of EN1 does not include text corresponding to the final sentence of paragraph 3.2.3, which was so important in the claimant's mind. That simply says that substantial weight should be given to the need for new energy infrastructure, although the text on greenhouse gas emissions is broadly similar to that in the existing EN1. On greenhouse gas emissions, and this is not a case that we're discussing in this seminar, it's not an NSIP case, but it's important to note the recent Court of Appeal judgment in Finch, which in my view is required reading for anyone promoting an infrastructure project which will result in greenhouse gas emissions. That case, as I'm sure many of you will be aware, concerned downstream or scope 3 emissions in EIA. So that's emissions resulting from in that case, the combustion of oil extracted pursuant to the development, rather than the emissions of operating the consented development itself. The Court of Appeal held that such emissions are capable of being a relevant material consideration. So whether or not to include or exclude these emissions in environmental statements, as well as the reasons for their inclusion or exclusion, will need to be considered by promoters in future. And if downstream emissions are not dealt with in an environmental statement, promoters will need to assist the examining authority with reasons as to why they should not be taken into account. Finally, it's clear from this case that there's a very broad role for planning judgment in these decisions. So the weight to be given to need and greenhouse gas emissions in the planning balance is not immutably fixed in the NPSs. Ultimately, it's for the Secretary of State to determine the weight to be given. So there's potential for more debate around these issues at examination stage, and perhaps less certainty on how the ultimate balance will be conducted. Although it also means that decisions are less capable of being challenged, since matters of planning judgment are generally not subject to review by the courts. So that's the client case. So turning now to Pierce. This was a challenge to a DCO for a proposed offshore wind farm called Norfolk Vanguard off the coast of Norfolk. And it was closely related to a second wind farm project, Norfolk Boreas. The onshore infrastructure for both projects was intended to be co-located by means of a cable route from landfall to the village of Necton in mid-Norfolk. The environmental statement for Norfolk Vanguard assessed the cumulative impacts of both projects, but when carrying out the assessment of onshore landscape and visual impacts, both the examining authority and the Secretary of State decided to defer consideration of cumulative impact because of the limited information available in their view on the Norfolk Boreas application, so the second application. The question for the court in this case was whether the evaluation of an environmental effect can be deferred if the decision maker or the environmental statement identify that effect as significant. And the court identified two possible approaches to cumulative effects of separate but linked projects. The first, it referred to a case of Larkfleet, where it had been held that one should consider cumulative effects in the EIA scrutiny of the first project, but then combine this with subsequent EIA scrutiny of subsequent projects. The other approach was based on a case called Littlewood that concerned future development on the same plot of land as the initial project. And in that case, it was held that where future development proposals are inchoate and no actual proposals have been formulated, there's no need to consider cumulative effects. In Pierce, the court held that that situation was more aligned with Larkfleet. The two projects were closely linked. The site selection had been based on a strategy of co-location, and the second project was to follow shortly after the first. Therefore, the court held that the failure to consider cumulative effects was in breach of the EIA regulations and was unlawful. The Secretary of State had failed to satisfy himself he had sufficient information to evaluate and weigh the likely significant effects of the proposal, and had indeed failed to undertake that evaluation. And the Secretary of State had also failed to give any properly reasoned conclusion on the deferral of the consideration of cumulative effects. The reason for deferral, that the information was limited, was also found by the court to be irrational. It was internally inconsistent. The same level of information had been provided on landscape and visual effects for both projects, and the examining authority and Secretary of State had been able to consider the impacts on Norfolk Vanguard itself on landscape and visual issues, but not of both applications. The Secretary of State also had the power to ask for more information if he wished, and he had not done so. Whether the village of Nexton was suitable as a connection point for both projects had to be determined before granting consent for the first project, so that the promoter could go away and perhaps find a different connection point if it wasn't a suitable site. And Norfolk Vanguard would also be a material consideration and a precedent in the DCO process for Norfolk Boreas. So the duty of consistency, which would apply in the Boreas decision, required some assessment of cumulative impact to be undertaken for the earlier application. There was also some discussion on relief in Pierce, as both the promoter and the Secretary of State argued that relief should be refused. And this was the first case to consider the concept of retained EU law in the context of EIA. The hearing took place just after the end of the transition period. So the court discussed the relationship between Section 31(2)(a) of the Senior Courts Act, where the test is where it would be highly likely that the outcome for the applicant would not have been substantially different, relief should be refused, and the more exacting EU law test, which considers whether the decision would not have been different. And the High Court held that it was bound by EU retained case law to apply the EU law test. However, in Pierce, even applying the lower domestic law test, the High Court held that relief should be granted, so there was no need to consider the EU law test. And that was mainly because there was no indication of what the Secretary of State's view would have been if he had considered cumulative effects. So finally, some points of interest and wider learning arising from the case. So this was a situation, I think, first and foremost, where the promoter was essentially hamstrung by the Secretary of State. They had provided all the relevant information to the examining authority and the Secretary of State, but both declined to consider cumulative effects and failed to ask for more information. And it's also clear from a reading of the judgment that the poor reasoning of the Secretary of State, who didn't explain what was meant by limited information, had a significant bearing on the High Court decision. So there's not that much more that the promoter could have done, except perhaps to emphasize the importance of assessing cumulative impacts at the stage of the first application. The next point is that the requirement to consider cumulative effects at the stage of the first application was expressed as a legal requirement. So this can be seen to be in distinction with the finding in Drax and Finch, where essentially matters were, or whether to take into account particular considerations was a matter of planning judgment, therefore much less susceptible to challenge. Next, both the applicant and the decision maker relied on the urgency identified in energy NPSs for renewable energy projects, but the court held that this did not absolve either from the requirement to comply with the EIA regime. And finally, just a point on procedure. So this was the first DCO to be quashed by a court following legal argument, following a hearing. Norfolk Vanguard and the Secretary of State both argued that it would be sufficient, pursuant to the infrastructure planning rules, to give interested parties a chance to comment in writing on particular matters before redetermining the DCO. Mr. Justice Holgate disagreed, and he said that in some circumstances, fairness might require more than this. For example, taking the matter right back to the beginning where there was a particular fundamental error. So it might be necessary to go back to the stage of resubmitting the application or holding another examination. But in the event, redetermination of this was dealt with by a written procedure inviting comments, and the DCO, a new DCO has been granted for Norfolk Vanguard just a couple of weeks ago. So I'm going to wrap up there and pass back to Melissa.
Excellent. Thanks very much indeed, Esther. Really interesting and useful. Thank you. I'm going to share my own screen now and see if I can get my slides up. There we go. So I'm going to be speaking on the Stonehenge Judicial Review Challenge, which many of you will have come across, I think. Do you know, we came as a family to live in this country in May of 1987 from a small coastal village in Ireland. My dad had got a job in the Peak District, and over we came as, I suppose, economic migrants. And perhaps to persuade us children that this new country had some merit, or maybe it was just to explore, I'm not sure. We often visited historic places and properties, buildings. I was quite a rebellious child, and I wasn't then, at least, particularly appreciative of what I saw. So we might go to a mansion owned by the National Trust, and it would strike me, well, it was a bit odd to be looking at beds, you know, never slept in, or sitting rooms never sat in. And as far as decorative ceilings and the like were concerned, well, I probably wouldn't have noticed them. And similarly, Stonehenge, you know, it was thrilling to drive up near the stones, but it struck me, you know, how odd it was that the road went so close and there were so many cars. And in truth, at the time, how annoying it was that it wasn't picnic time, and so we drove straight past it. Here on the slide, you have, I think, possibly a more appreciative visitor. You've got the Lucas de Heer watercolor sketch from the 16th century. That is credited as one of, or even the earliest realistic images of Stonehenge, although it looks, perhaps it's the scale of the slide, it looks to me a little cartoonish. It's held at the British Library. He was incidentally a refugee from the Dutch revolt in his lifetime, much celebrated in this country and remembered still. My childhood recollections from West Country holidays, arguably I would accept a little off topic, but they're not actually, forgive the pun, a million miles from what underpinned the application in the Stonehenge DCO. As I've set out on the slide, the existing A303 route was proposed to be much altered, particularly at the Stonehenge World Heritage Site. The DCO application was for the construction of a new route. You can see on the slide, 13 kilometres long between Amesbury and Berwick Down, replacing the existing surface route. The new route would have a dual instead of a single carriageway, and would run in tunnel through the Stonehenge part of the Stonehenge, Avebury and Associated Sites World Heritage Site. Importantly, the proposals included a western cutting, western tunnel portal, the entrance to the tunnel, and the Long Barrow Junction, all of which attracted much opposition. Now, I've mentioned some specific issues. The World Heritage Committee, it was concerned about the section of exposed dual carriageway at the western cutting. And so essentially what it wanted was that the tunnel section would be extended to approximately 5 kilometres so that the western portal would be outside the World Heritage Site. And an alternative to the 3.3 kilometre tunnel was in fact considered at examination. And I thought it was particularly striking that the panel said that the western cutting would introduce a greater change to the Stonehenge landscape than has occurred in its 6,000 years as a place of widely acknowledged human significance. Moreover, the change would be permanent and irreversible. So, bearing in mind that this is a place which is for centuries, if not longer, exerted a fascination, you know, protectiveness and curiosity. Obviously, although the proposals were, I think, well intended, they were hugely controversial, and you've got the controversy at an international level, as you've seen from the bullet point on the slide. There, the key concern being the portal and the cutting. Obviously, that would cost a lot more, but in this landscape without parallel, and certainly for people not footing the bill, that was seen as a price worth paying. And controversy too at a national level, with significant participation at the examination. Now, the examining authority had serious concerns regarding the effects of elements of the proposed development on the outstanding universal value of the World Heritage Site and on the cultural heritage and the historic environment of the wider area. And those concerns related to the Western approach of the cutting in the Portal, the proposed Longbarrow Junction, and to a lesser extent the Eastern approach in Portal. They concluded, as I've noted on the slide here, that substantial heritage harm arose. They recommended refusal, disagreeing with the applicant's assessment of overall impact, disagreeing with the advice of Historic England as to the overall impact of the scheme. As we'll see later, and this is important then in the later challenge, didn't provide a précis or summary of the submitted heritage impact assessment or environmental statement in relation to the significance of or impact on heritage assets where the panel agreed those assessments. And they concluded that the options appraisal work was sufficient rather. I mean, I think just to understand their concerns in a little more detail, it is just worth going back to the panel report as I have and thinking about what it was in particular about the cutting that they were concerned about. They said that the importance to ancient people of the dynamic experience of moving within and making ceremonial and practical use of the assembly of landscape and monuments is clear, as is the significance to early Bronze Age communities of the monumental symbolism created by their ancestors perhaps 2,000 years earlier. And they said that the space between the groups of monuments contributes greatly towards their significance. And they drew a comparison between that space and in a similar way, the open courtyards and other spaces within a medieval complex of listed buildings contributes to their significance. And in the examining authority's view, the panel view, this part of the World Heritage Site would be seriously disturbed by the intervention of the cutting in the Western Portal. Their concerns revolved not so much around the appearances from static and far distant viewpoints as the presence of the cutting in the context of an unparalleled historic landscape, so its presence. There had been at the examination, it seems, criticisms of the presentation of impact, and it's possible that the panel agreed, although it's not in fact clearly stated that if they did. Turning then to the Secretary of State's decision, you can see on the slide disagreement with the panel, not substantial harm, but a finding that less than substantial heritage harm would be caused, as you will know. I think then a different policy test question as to whether the benefits of the scheme would outweigh that harm. The Secretary of State did not, as a matter of fact, receive any separate briefings or précis dealing with the significance of or impact on individual heritage assets, those individual heritage assets in relation to which the panel simply accepted the content of the submitted heritage impact assessment or environmental statement. And the Secretary of State accepted what the panel had said about options appraisal work. So why was the decision quashed? The first successful aspect of the challenge was to the Secretary of State's judgment that the harm identified by the panel as substantial should be treated as less than substantial. And as part of that, the court found that by whatever means he or she, i.e. the decision maker, employs, they must ensure that the significance of each designated heritage asset affected by the proposed development is taken into account, as is the impact of the proposal on that significance. So this is per the Bramshill case, one I was involved in for the National Trust, right through to the Court of Appeal level. The court, in that case, Court of Appeal, espoused a fairly liberal approach to assessment, but emphasised the need to weigh all relevant effects properly in the balance. The court found that although the Secretary of State disagreed with the panel's conclusions, he didn't disagree with the more specific findings of the panel upon which its substantial harm conclusion was based. And Holgate, Mr. Justice Holgate said that this part of the decision wasn't challenged as irrational. Now, what I've understood about that part of the judgment is that he meant not Winsbury unreasonable, wasn't looking at a separate limb of irrationality relating to justification. On analysis of what was before the Secretary of State, the court simply wasn't satisfied, bearing in mind the content of the panel report, where some aspects of assessment were simply accepted and not summarised, that the decision maker had legally sufficient information. The treatment of alternatives, second part of the slide, is really interesting, and it's important. We're going to look at that on the next slide too. In short, the court wasn't persuaded that it is sufficient that an applicant has considered options, and this is, you know, the application scheme is the best, a sort of second-hand or supervisory exercise. In the particular circumstances of the case, the decision maker ought to have weighed up the application against the alternative. And there's, in my view, the muscularity really of the common law is being asserted here in the judgment. I do think it is of particular importance, this, in the way in which promoters think about project risk and how to mitigate that, and of course important for objectors too. Now, I'm going to, I see that I've got a question on the slide. It's quite a detailed one, so I'm going to just park that for the time being. I'm going to come down to the next slide. Here we go. Well, are there any learning points? Yeah. Well, you might argue, you might even argue successfully, that there's more for decision makers here than either promoters or objectors. I do think it's an interesting case to reflect on with you. And some of you might have thought, well, not so much for either promoter or objector, but actually, as far as promoters are concerned, the importance of common law principles here in this development consent order context should, I think, and will have given pause for thought, needs to be considered, I think, in terms of the assessment of risk and mitigating it. There's obviously much here too for objectors. Now, I just also want to mention two particular points that I've set out on the slide. Heritage. The submission material is not what was said to be at fault, although I've noted that particular possible criticism of, in terms of the presentation of impact. There is a requirement, isn't there, to weigh the impacts on significance of a proposal on designated heritage assets per Bramshill. That then gives rise to a need for methodical and meticulous assessment of historic significance and of impact. If the promoter has already done so, then of course it falls to the decision maker to do likewise. But what about alternatives and the adequacy of alternatives comparison? In circumstances in which there is a clear planning objection to development on a particular site, then the consideration of alternatives or an alternative may well be relevant and necessary to consider whether there's an appropriate site elsewhere. That's per Trust House Forte. Well, that's easily stated, but I mean, potentially that is quite a vexed issue. How far does one take the assessment of alternatives, perhaps on without prejudice to a primary basis, to one's primary case? Potentially quite expensive, but also in question quite how that plays. So I do think that is worthy of really careful consideration. So for the time being, this is what we have: a surface route, which of course in theory can be restored, and a decision which requires to be retaken. And I understand, my understanding is that representations have been sought very recently on the redetermination. And the issues remain outstanding. And just in terms of the picture itself, I mean, obviously this isn't the view from within the family car. Perhaps you have your own experience, maybe even similar to mine. I did just want to take just a couple of additional moments of your time, though, to think about what else might we take from the judgment. And I just ask you to note that Appendix 1 to the judgment is legal principles which were agreed between the parties. So it's by way of a legal statement of common ground. It's actually really quite a helpful, quite helpful material for the neutral observer on such matters as policy interpretation matter of law, obviously application for the decision maker, on reading decision letters, a few paragraphs there on agreed approach, I think quite helpful, ditto reasons, material considerations to agreement as to the correct approach in this DCO context on that. I would just point out, I thought was interesting, that the Regulation 3 of the 2010 regulations was treated as, and agreed to be, equivalent to the Section 66, which in effect then applies the case law relating to preservation generally to this DCO context, which it seemed to me offers, particular opportunity and risk depending on your perspective. So that's certainly worthy of consideration, and that appendix in general, in fact. Now, just before we turn to the questions section of the seminar, I just want to mention a couple of points to you. One is the slides that we've all been speaking to. We're going to circulate those afterwards via email. We'll also send a link of the recording to everybody. And actually, I said there were 2 points. Obviously, there are 3. The third is that we have a planning forum coming up. So not just infrastructure, but planning a bit more generally. That's on the 25th of April, and invitations are going to be sent out soon on that. Now, so I'm going to stop sharing my slides, and we've got a couple of questions. One was Angus Walker was asking, made a comment about a particular judgment. I think, Mark, that was, if you want to put your camera on, if you're able to. There we go. Yeah. I think that might be one for you.
I think, yeah, I think it was a reference to the EFW case. Yeah, well, I'm prepared to agree with Angus that it is a curious judgment. And I think the key point that Angus is making there is, well, did you really have to grapple with Section 105? Was it not associated development? And I think that could be a material question to ask in many cases. In this case, the particular development, WKN, was a standalone EFW facility that was capable of generating 42 megawatts on its own. So it was well on its way to being an NSIP on its own. And associated development is that in the Planning Act and in the guidance, it says it shouldn't be an aim in itself, should be subordinate to the principal development. And so I think a judgment was made early on by the applicant. I wasn't involved, I only came in for the legal challenge, but it seems to me that there was a judgment made that they are really 2 distinct projects and it was too big to be within that associated development bracket. But I think it's an important question in every case, whether something falls within associated development or otherwise. But on this one, it was pretty big.
Interesting. Thank you very much indeed, Mark. Esther, do you have anything that you wanted to add on that?
No.
Then I think, again, I'm not sure if it's a comment really or a question in terms of Stonehenge and the consideration of alternatives. I think it is interesting that you have the panel certainly seemed to be satisfied by the options appraisal work which was undertaken, and yet you have the court finding fault with the way in which alternatives are considered. So that is a conundrum, but one which I think is going to be the subject of some very detailed attention in the next round of submissions. So that will be interesting to see. Well, listen, thank you very much indeed, Mark. That really was a very useful and informative talk. Ditto, thank you very much indeed, Esther. And thank you to all of you for joining us for the second in our of this term's infrastructure seminars. And we hope that you will join us for our subsequent talks and presentations. Thank you.